All right, well, welcome to the webinar on estate planning issues financial planners should recognize. My name is attorney Matt Parker. Today I'm going to review some of the common issues that come up in estate planning that maybe a financial planner should recognize when they're reviewing their client's estate plan. Now, most financial planners do have some obligation to ask their clients if they do have an estate plan. Now, whether or not you can get the clients to draft one is a completely different matter, but at least you should be encouraging them and advising them of the general consequence of not having a plan. So the following 10 topics are intended to be helpful in the issue spotting of your job. One or more of these topics may exist in the client's family or maybe finances that could lead to a referral to an estate planning attorney. Now, you can ask some questions as we go along, and hopefully I will have time to respond at the end of the presentation. Now, avoiding probate on the death of the first spouse in a marriage is one of the first items I look for when reviewing a client's finances. I often ask, why are there solely owned bank accounts or maybe a mutual fund or real estate in one of the married couple's name and not the other? Is this a second marriage and they've just kept the assets separate? Maybe one person brought the real estate to the marriage. What I find is that in many cases, this asset has been in one spouse's name for 40 years, and they just never got around to putting the other spouse's name on the real estate or other account that they brought to the relationship. So there's no longer a good reason not to have the other spouse's name on the title, so I talk to them about what could occur if you don't do that. So with solely owned assets, without a reason for the solely owned assets, I like to see them jointly owned with the right of survivorship, or of course, if the accounts can have a beneficiary designation on the first spouse to die, I will look for that as well. Now, miss an asset, and you could be calling the lawyer at the death of the first spouse to ask for the cost of probate for this one $22,000 account. In my experience, the surviving spouse won't appreciate having to pay those lawyer's fees just to move this one account into their name when the will did leave everything to the surviving spouse. Testamentary trust planning is often used in an estate plan. And these are trusts that are funded after the death of the client. Now, there's a whole host of reasons why your client might need a trust in their estate plan. There could be reasons to manage the assets for a child, a grandchild, and maybe even a surviving spouse. So here are a handful of the reasons why you might see the need for a testamentary trust. First of all, there's a disabled beneficiary. This could be a child with a mental handicap with the likelihood of needing care during the rest of their lifetime. Many of these cases will lead to government assistance through programs like supplemental security income or medical assistance. Both of these programs have asset limitations. So if a client leaves an inheritance to this child or grandchild who has one of these government benefits, they may have to spend down the inheritance to keep those benefits. So I recommend using a special needs trust. This is a vehicle that's typically set up in a will or a revocable trust to collect the money that would otherwise be paid to a disabled beneficiary. And then an adult or a trustee manages that money for the disabled beneficiary. The inheritance left to the trust is not, of course, owned by the beneficiary, so it can't be counted for the purposes of their continuing eligibility for benefits. Keep in mind, these trusts need some very strict terms to keep them from being counted for government assistance. Now, another good reason for a testamentary trust is for those beneficiaries that you do not want to leave an inheritance outright. They could have all sorts of problems, maybe with just managing money. Sometimes it's more serious, like a drug problem, some creditor issues, or maybe they're in a bad marriage and the fear is that divorce might occur in the future. Now, once again, your clients probably want to leave money to this person, but not outright. So you use a different type of trust in these cases. These are commonly called spendthrift trusts. They're placed in the client's will and they're funded at your client's death. There is typically a trustee put in control of the money that you leave to the trust. The trustee can then pay for what the beneficiary needs, but the beneficiary doesn't own what's in the trust. nor can they demand from the trustee the trust funds. Oftentimes, there's a professional trustee, such as a bank, that will be named as the trustee, particularly if these trustee funds are rather large. And lastly, the spouse may be the party in need of a testamentary trust. Perhaps this is a second marriage, and the desire is to leave the inheritance in trust for the surviving spouse under certain terms and conditions. Perhaps the spouse may be facing long-term care in the future, such as nursing home care. It's best to avoid leaving the inheritance outright to them, as it may be exposed and counted for the purposes of medical assistance that would pay for their care in the nursing home. Now, the family business can be one of the most complicated assets in the estate of a deceased client. Now, this is particularly true if no pre-planning has been done to lay out what is going to happen to the business. The best plan, of course, is to have some sort of sales agreement or arrangement set forth prior to death. Will the business pass to the existing employees or the family members? How's the business going to be valued? Will the sweat equity of those who are working in the business be considered? How about the terms for forgiveness of any note or balance due at the time of death? Now, all of those factors could come into play in determining how these business interests are addressed at the time of your client's death. Now, if you fail to plan for these cases, I have seen chaos result with regard to these businesses. Estates obviously are not allowed to run a business after death without a court order due to the possibility that the cost may drain the other personal resources. So some of these businesses may not survive the transition to the next generation without a really good plan that is done during the owner's lifetime. Now, if the clients want to leave a specific asset, such as the family farm or the cabin to one child and not another, have they followed through with that in their will or other document like a revocable trust? If a client mentions that they'd rather leave the farm to their son and maybe the investments to the daughter, then you need to do some specific wording in the will addressing that division. You'll also need a tax clause that addresses how inheritance taxes are to be paid on the specifically devised real estate. Will the taxes be paid from the residue, or are they going to be paid by the recipient of the real estate? Sometimes clients want an option to purchase the family homestead given to a number of individuals in the family. If that's their desire, that needs to be set forth in the will with some time frames for exercising that option. Also, what about specific gifts of money to grandchildren? Maybe charities. They have collectible cars or other valuable assets that should be designated to one or more beneficiaries. They start talking about that collectible item they have in their household or particularly meaningful to them, and it has some value that should be set forth in the will of the client. Now, if you find any of those wishes, you probably need to advise your client to sit down with the attorney and specifically set forth that in the document. Now, a common problem in an estate plan is having a sizable inheritance tax obligation and rather limited residue to pay that tax. I often look for accounts that can be used to pay the expenses of administration, such as taxes. If we don't have a lot of probate assets, are we going to be using life insurance to pay the tax? I find that sometimes financial advisors get a little too aggressive in trying to avoid probate, and they end up paying all the investments via non-probate designations, and they leave no money to pay estate expenses such as inheritance tax. It can be very challenging then to chase the non-probate beneficiaries for their share of the tax. Now, I'll point out that occasionally there are exemptions from the Pennsylvania inheritance tax. They include operating farms and family businesses. However, those have to pass to specific family members in order to be exempt from the tax. Now, when it comes to gifting during lifetime, make sure that clients understand that highly appreciated assets, typically real estate and stock, will receive a step-up in tax basis upon their death if it's included in their estate for inheritance tax purposes. Too many clients want to give homes away during their lifetime. Although there are examples where this might be appropriate, such as farmland that's in the Clean and Green program, or maybe a child is residing in the home, most of those transfers of highly appreciated assets will result in a capital gains tax obligation for the recipient once the property or the asset is sold. Now, that could be 15% on the appreciation. With the inheritance tax rate to children at 4.5% here in Pennsylvania, the inheritance tax is often the less significant of the two taxes with those highly appreciated assets. Now, if your clients have high net worth, the federal estate tax program now has a very high exemption amount from that tax. The federal government recently raised the amount of an estate that is free from federal estate taxes to $11.4 million per person. Now, that's $22.8 million in a marriage. And with the concept of portability, it's no longer important to have equal ownership of the assets, as the unused exemption can be claimed by the surviving spouse. Now, we don't know what's going to happen to this tax system in the future, but I'll point out in the last 20 years, the exemption has gone from $650,000 per person in 1999 to $11.4 million in 2019. I question, what is this tax going to look like in 10 years, even 20 years? A nursing home cost can quickly drain the savings of the client with average wealth. Some discussion should be had about asset protection planning. Are they wealthy enough to self-insure? Long-term care insurance has recently taken a hit as a popular technique to protect against the risk. There may be some sort of hybrid policy, that is, with life insurance benefits that works for some wealthier clients, but long-term care insurance certainly is not the most popular investment at this time for many clients. So some clients may want to consider transferring title of assets that are exposed to the long-term care risk. Typically, they ask about transferring those assets to a trust. These irrevocable trusts are often set up as grantor trusts, so that the income tax obligations and benefits can still be attributable to the person setting up the trust. They're often called asset protection trusts, and they're designed to protect a home or other real estate, as well as savings from the costs of nursing home care. So when clients ask me if they should turn their home over to their kids, I tell them that there are probably better ways to protect the home. Usually, using a trust makes more sense. Now, the terms of the trust let you live there, not only for the rest of your life, but the kids only own the house and the assets in the trust when the clients die. And it's a tax advantageous trust. The kids can avoid capital gains tax when they inherit the home. They're going to get the step up in tax basis. If the clients ever want to sell the assets in the trust during their lifetime, all the tax benefits are attributable to the grantors. They can even avoid the capital gains tax on the sale of their own residence. Now, clients can also put other assets in the trust to avoid them being counted if they ever apply for medical assistance. Those investments include stock, mutual funds, deferred non-qualified annuities, as well as bonds. Now, although these trusts do have ways to remove the assets for the benefit of third parties like children or grandchildren, they're not intended to be used for ongoing expenses of the grantors. So not all the savings that the grantors or your clients have should be transferred to such a trust. Keep in mind that these trusts must be funded at least 5 years prior to the application for medical assistance, so the transfer to the trust can avoid affecting eligibility for those benefits. Now, second marriages can be the most difficult estates to plan for. In a Brady Bunch scenario, the husband brought kids from a first marriage, and the wife brought kids from a first marriage as well. They typically want the kids from the first marriage to inherit some of the estate. Now, if they leave everything to the surviving spouse, he or she could remarry and then cut out the kids from the deceased spouse's first marriage. Now, quite frankly, what happens is the kids from the first marriage oftentimes don't get along well with the spouse in the second marriage. And there's really no incentive for the surviving spouse then to leave much of anything to those kids if he or she has inherited everything from the deceased spouse. So if you want to ensure that some sort of inheritance goes to those first marriage kids, you need to do some creative estate planning. Some ideas include having the separately held assets, and each one of the spouses has a separate estate plan. In addition, they could have pre- or post-marital agreements. They could also have non-probate assets like life insurance that pass maybe to the surviving spouse, while other assets pass to the children of the first marriage. Some other ideas include a marital trust that's in the will of the deceased spouse, and some of those assets pass into trust for the surviving spouse, who then has limited rights to the income and principal. At the death of the second spouse, what's left in that trust passed to the kids from the first marriage. If you have real estate brought to the marriage by one spouse, what you could have are real estate provisions in the will that say the surviving spouse has the right to live in the property for the rest of his or her lifetime. But when that spouse dies or leaves the real estate, the property is sold and the proceeds are divided amongst the spouse and the kids from the first marriage. So there's lots of issues to address in these cases. Be forewarned that if there's not proper planning done with these second marriages, there's going to be some really hard feelings and some tough issues to work out. Now, many clients will do a basic estate plan when their children are minors. There will be a minor provision, for example, as to who will be the guardians when the parents are not around. Maybe there'll be trust for those minor children up to a certain age. Now, as the children become adults, these wills quickly become outdated. The trusts are no longer relevant. The guardianship provision doesn't make sense. So they need to be updated and include the children in roles such as the executors. And if you're doing powers of attorney, the kids need to be named in those documents when you realize, well, this child really could handle things for us if we're not able, and the other child perhaps is not the best choice. Your kids become adults, and you realize who's best served in one of these roles. Now, estate planning documents can also become outdated due to changes in the law, such as the estate planning provisions that are no longer relevant. Too often we see documents that were drafted in the late 90s and early 2000s that had those mandatory bypass, or what they called AB trust planning. Now, those concepts are really outdated now for most of our clients, as is the need to separately title the assets. So if you ever see boilerplate revocable living trust documents that tend to have those outdated or unnecessary provisions, those probably need to be revoked and a much more simple plan put into place. Now, financial powers of attorney also need to be updated regularly. As you know, some financial institutions object to financial powers of attorney that are really old on the grounds that they've been perhaps replaced, or the form is not consistent with the current state-approved version. Keep in mind that states tend to update the forms of their powers of attorney every 5 to 10 years. Also, powers of attorney should be updated for your older clients to ensure that changes can be made to their estate plan to protect their estate from either long-term care costs or taxes. Older, rather conservative power of attorney may not have had a clause that allows for the transfer of assets between spouses, including real estate, and it may not have a provision allowing for asset protection from nursing home costs. Keep in mind that the new form of financial powers of attorney in Pennsylvania requires a whole host of powers to be specifically granted to the agent, or they cannot be exercised. They include the gifting power, such as taking names off of investment accounts or real estate. They also include changing beneficiaries and placing or removing names on a bank account. Well, grandchildren will often take on a significant role in a client's life. They may want to benefit their grandchildren in the estate plan. So I often ask them, do they want to leave money to a minor grandchild? If so, perhaps we could use a minor's trust, or maybe reference the Uniform Transfers to Minors Act, which will allow a custodian to set up an account for that minor. They need to pick an appropriate age for when the minor is going to receive the funds outright. Is it going to be age 25 for a rather modest inheritance or some older age? Now, if the inheritance is significant, is a testamentary trust beneficial? Should money be placed in a trust and managed by a trustee and then distributed based upon a standard that will benefit the minor? Maybe there should be ages of distribution from the trust. Maybe it's staggered at age 30, 35, and then 40. Lots of thought could be put into the larger inheritance when the client really doesn't know how this minor is going to behave when they reach adulthood. So we need to be very careful not to leave large sums of money outright to young people in the estate plan. The last item, recommendation for you, is to discuss with your client a letter of instruction for those that are going to handle their affairs when they are unable to do so for themselves. A letter of instruction is a roadmap for children or agents who need to get involved in the parent's financial and personal affairs. Some of the topics that are put in these instructions include contact information for professionals such as financial advisors, lawyers, and accountants. Perhaps a list of an accounts. Where is your money invested? The assets. Nowadays, you need passwords if you have online accounts. Where are those located? The location of documents. Where did you keep the power of attorney? Is it in a safe somewhere? Who knows? Instructions regarding personal affairs. It could be pets. What do you want to have happen to the cat or the dog? Burial arrangements. Health-related matters. Who are your doctors? Who's handling what affairs for you? All of those things would be nice to have instructions so that when a crisis occurs and someone has to step into your life, they can find that letter and they have a place to begin to understand what was going on in your life. So it's an easy document to put together. Does not necessarily need a lawyer involved. Obviously, we have forms for that, but clients can find all sorts of forms online for letters of instruction. Well, that will do it for my top 10 estate planning issues financial planners should recognize. I'm sure I could have come up with another 10, but hopefully one or more of those will be helpful to you. Please visit our website at paelderlaw.com for more information. Thank you all for attending.